You are watching Access LaPorte County, Channel 97. Coming up next is the October 24th, 2023 meeting of the LaPorte County Plan Commission. You can find more information for this meeting by visiting www.accesslaportecounty.org.
Good evening. We're going to call the Plan Commission for Tuesday, October 24th in session. Joe, could you please lead us in the Pledge of Allegiance?
Certainly.
I pledge allegiance to the flag of the United States of America, and the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Okay. If anyone has cell phones in here this evening, we please ask that you put them on mute or vibrate at this time. And we'll call the meeting to order. Roll call, please, Ashley.
Rita Beatty.
Here.
Earl Cunningham.
Here.
Glenn Minnick.
Here.
Harold Parker.
Present.
John Carr.
Here.
Deb Vance.
Here.
Joe Haney.
Present.
Tony Hendricks.
Thank you. Would like to have an approval for the agenda for this evening?
So moved, we approve the agenda.
Second.
All those in favor signify by saying aye.
Aye.
All those opposed? Okay. We'd like approval of the minutes from the last meeting of October 3rd, 2023.
Move to approve the minutes as presented.
I second.
Any discussion? All those in favor signify by saying aye.
Aye.
All those opposed? Thank you. Motion carries. This was the plan. That was the plan meeting. Last meeting. Okay. Right. Thank you. We'd just like to make a couple comments here at the beginning. There will be public comments for remonstrators that are for or against any of the petitions this evening. And at that particular time, we do have a timer set up this evening for 3 minutes. If there's anyone that would like to speak for a group, we may allow a little bit more time. Otherwise, we're going to ask that you limit yourself to 3 minutes. And we're going to stick with the facts. No hypotheticals in here this evening. And I guess that's it for right now. So for the first petition, we have petitioner the D&M Excavating, represented by counsel of Andrew Volz of House & House. Petition for the Plan Commission for a 39 lot with 1 outlet major subdivision called Sable Estates, located immediately south of 3786 North 400 West, LaPorte, Indiana. Center Township, parcel number 4606-17-200-002.0000042. Please proceed.
Thank you, Madam President. Good evening.
Notice is adequate.
Thank you, Mr. Biji. Good evening. Madam President, I understand you've stepped up in the role of President tonight because Mr. Hendricks is not here. So I would like to greet all of the board members here tonight. Ashley, Commissioner Poland, Mr. Biji, Mr. Bishop. We are here because of a petition for a major subdivision concerning a 39 lot plan with 1 outlot, and this is a major subdivision called Sable Estates. You've already read the legal description. As far as we go through this, the petition is what it is. It's a petition for a major subdivision, and the proposed preliminary layout is attached.
Excuse me, Andrew, they're asking that you speak maybe a little bit louder, so I don't know if you can put the microphone up closer maybe.
I've never been asked to speak louder, but okay. The petitioner does submit to the Plan Commission a copy of the primary plat for the proposed subdivision, now called Sable Estates, but will be plotted into 6 separate units, meaning that it's going to be 6 distinct states or otherwise phases. Let's call it phases. The proposed subdivision will be served by private septic and wells. Improvements will need to be placed in the subdivision, including but not limited to streets, curbs, gutters, and stormwater conveyances. appropriate protective covenants and restrictions will control the use of the real estate in this subdivision, and which copies of will be furnished to the LaPorte County Plan Commission at the time of the public hearing, meaning the secondary public hearing. Because what we're doing here is we are following the major subdivision ordinance that's been incorporated by LaPorte County under Article 4. And I'm sure Mr. Beege can go ahead and walk through everything under Article 4, subsection 1, 2, 3, subsection G, all of that with regards to what you are looking at here. And what I'm going to do here at this point, well, first of all, notice is adequate, and this property is zoned R1B. This is not agricultural, this is not industrial, it's R1B. We have an individual from, well, Matt is his name, and he's with Tony Hendrick's office, which is the reason why he's not here, because he had to step down. We'll just be clear about that. And Matt will come up and present to you all of the requirements and the clarifications for what is required under a review for a major subdivision pursuant to the joint zoning ordinance. Matt?
Good evening, everybody. My name is Matthew Garatano from Charles Hendricks and Associates Surveying and Engineering. Our offices are here at 512 Lincoln Way in LaPorte. Like Mr. Volt said, specified earlier, this is an R1B zoning, some major subdivision named Sable Estates. The key takeaways here from this subdivision, one, most important, are we are not asking for any variances. So we are abiding by all R1B requirements. The main being the lot frontage, the lot size for R1B. This entire plan meets or exceeds those requirements. 24,000 square foot a lot. Each lot meets or exceeds that size. 100-foot frontage. Each lot meets or exceeds that size. What we're trying to do here is try to be harmonious with the surrounding community in creating more R1B home sites. That's the basic goal. Like Mr. Volt stated earlier, the wells and septics will be private. I do believe you guys should have gotten notice from the LaPorte County Health Department that the soil boring reports for each lot were sufficient. I don't know if you got the notification regarding lots 12 and 13. There were borings done on 13, that is the pond lot. So there's going to be no home on there. Amanda reiterated that also lot 12, there was some insufficiencies there as far as I think it had to do with the existing contouring. So she omitted lot 12 as well. On this plan, most likely 12 will either be amalgamated into 13 or the adjacent lots next to it. It will not be a buildable home site. As far as the road goes, we're going with county specs. You can see that on sheet 1 in the lower right-hand corner of the detail. That is 60-foot right-of-way with 28-foot wide pavement and 2-foot flat concrete ribbon curves. As we go through the petition package, you can see the phases 1 through 6. And because the shape of the parent parcel, we had to do the lot layout for sheets 3 and 4 on 2 separate sheets, simply because of the size and shape. There you can see the vast greatness that is lot 13, that is the pond lot. Moving forward past that, there aren't really, because we're not asking for any variances, there aren't really many elements to this petition. It's pretty straightforward. I know that in the technical advisory meeting, there was a consensus of a concern for site distance. I have some Google Earth photographs of the road if you would like me to present that to the commission to show you what we're looking at as far as site distance on the exit or the entrance exit for the parent parcel. If you guys would like to see that, I can present it to you now if you'd like.
Is that important to see that?
I think that
I
might
think
be
so.
something that would be appropriate. Yes, please.
So here's the main sheet. You can see on there we got about 500 feet.
You don't have any copies, just one sheet?
No, well, the overall sheet is, but I've got the photos, which are the most important part.
Thank you. We can share. Can't we?
Sure, I guess.
Thank you.
Thank you.
Aside from site distance, which was a concern for planner and the county engineer, we do believe that there is adequate site distance there. If there is, I don't know the date of the Google Earth photo, but if there is any vegetation that creeps into the right-of-way, I'm sure that the developer and the highway department would be able to work together to maintain that adequate site distance for the entrance exit. On sheet 12, you get to see all the borings. I do not have a copy of that report, but like I stated, the health department has that report in full. And the other item that came up in the secondary technical advisory meeting was the sheet that is not in your packet, but I understand was distributed by the building department for street trees. So code requires us to put one street tree per lot, and then there's also a specific code for the pond that is on that sheet. And if we are granted approval for primary plat, those will be implemented into the construction plan for approval for the construction plans in the next phase after this. And that's pretty much it for R1B major subdivision, Sable Estates.
Okay, thank you.
You're welcome.
Before you step away, any questions at this time for Matt before he steps back? Okay. Well, Mr. Volz, are you?
4.2, which is regarding the primary plat. And so we're talking about subsections A, B, C, D, E, F, G, H, and I. And specifically, this board is charged with approving the application upon the determination that the application complies with the ordinance, or approve the application subject to certain modifications that would bring the application into compliance, or deny the application on the grounds that it does not comply. We would submit here at this point that this application complies with the ordinance. Then if you follow up then with subsection G, the Plan Commission shall determine if the subdivision plat qualifies for primary approval under the standards prescribed by this ordinance, including standards for, so the way you read that, it is including but not limited to, minimum width, depth, and area lots in the subdivision, public way widths, grades, curves, and the coordination of subdivision public ways with current and planned public ways, the extension of water, sewer, and/or other municipal services, and allocation of the areas to be used as public ways, parks, schools, public and semi-public buildings, homes, and utilities. Matt has identified all of these things. I would go so far as to say this is probably the most extensive subdivision application that I have ever seen. It is above and beyond what is required by the ordinance. And I understand that there's a whole lot of political stuff that's going on around this as I'm looking at this over here, and I'm seeing Mr. Friedman here, and I'm seeing all of these things that have nothing to do with the application. The application is the application. And whether a remonstrator is going to get up here and make some comment about pending litigation or whatever else, then I would be more than happy to come back up and indicate that we are working through that. And this, in fact, is what was required by the stop work order. To submit a plan. We've submitted a plan. So for anybody to come up here and make a comment that this is just a guise or a ruse or whatever else is irrelevant and inappropriate. We have an application under Article 4 of the subdivision ordinance We have met the requirements, and we would ask that it be approved. Thank you.
Thank you. Any questions or comments from the board at this time? Before we open up to our administrators? Okay. All right, hearing nothing. If, once again, when you do come to the podium, please state your name and your address for the board. Speak into the microphone. We do have public online this evening for Zoom, and we want to make sure everyone can hear everything, as they said, as indicated previously. So, County Council, I'd like to ask before we get started if there's any concerns that we need to address prior to.
Well, first I want to confirm, Mr. Friedman, who are you representing tonight?
Represent the Board of County Commissioners.
All right, I want to make sure we got a clean record. I do not think it's appropriate that Board of County Commissioners remonstrate because they're the ultimate decision makers here. Okay? That said, you can go ahead, so we have the record, but we're just trying to keep it clear for the Court of Appeals for later, if anything's appealed on either side. Okay?
Okay. Thank you.
Thank you. Thank you, Madam Chair. Good evening. Attorney Shaw Friedman representing the Board of County Commissioners in the suit currently pending before Special Judge Jeffrey Clymer, captioned Board of County Commissioners versus D&M Construction. I had not expected to be present for this hearing tonight until last Wednesday's status hearing in court, when the attorneys for D&M stood up in court and announced to the judge that as soon as they received permission from this board for their proposed subdivision, they intended to file a motion to dissolve the injunction that was granted August 4th to allow them to start removing and reselling more sand from this disputed parcel. Once Commission President Grammarosa heard about the court hearing, she directed that I be present tonight. Don't let anyone tell you that this petition and the litigation aren't related. They absolutely are. Furthermore, as you go about reviewing this petition, don't let anyone tell you that the track record of the petitioner at this parcel isn't relevant to your determinations. In fact, Indiana Code Section 3674601. 3674601 tells us the whole purpose of the joint zoning ordinance is to promote the public health, safety, comfort, morals, convenience, and general welfare. Hard to believe, but I would wager this is the first petitioner ever before this board that has a petition for subdivision on a parcel pending at the same time that they've sued the county commissioners in a counterclaim seeking money damages, claiming, and I quote, that their investment-backed expectations for this residentially zoned parcel have been harmed. It is the position of the Board of Commissioners in the litigation that there have been a series of misrepresentations and contradictory statements given to county officials over the past 8 years regarding this residentially zoned parcel and non-compliance and non-cooperation, all of which made it into the judge's August 4th decision, which you're going to see tonight. We're going to give you copies of that as well. I have copies to present for the record. What has turned into a dry excavation pit was supposed to be, and Mr. Minnick, Mr. Parker will remember, we were here 8 years ago. And I want to provide for you copies of the minutes from that meeting. This Plan Commission meeting where several of them, I think Ms. Beatty, you may have been on the board at that time as well. This was 8 years ago, where these folks were in front of you.
Yep.
And August 4th, again, we're providing you copies of those Plan Commission meetings. The August 4th order, which I will have copies for you for the record as well. What has turned into a dry excavation pit was supposed to be a 3.5-acre pond next to what Ryan Miller said was going to be his dream home. County officials, including this board, acted in reliance on representations that proved false and nothing but a cover to conduct highly lucrative commercial sand removal operations at this site. Now let me be perfectly clear. I'm not saying that D&M Construction isn't a good local firm or that they don't have a record of performance and community involvement elsewhere in our community. But when it comes to this site and Ryan Miller, it's a tale of two companies. I'm not sure whether it's because of personal animosity between Mr. Miller and the neighbors, or the sheer value of the CH1 construction sand that is just underneath this parcel. But D&M's actions have resulted in what Mike Poland described in court in front of a judge as unprecedented in our county. 4 different stop work orders issued over the past 8 years. Now, you all know, just as a bank will rethink giving a loan to someone who hasn't been straightforward, government won't renew an SBA loan or grant if there's been contradictory information or misleading information given in the past, you all have the opportunity, in fact, the duty to inquire as to how candid this petitioner has been at this site and whether they've been a good neighbor as well. On both counts, at this site, they've been misleading and misinforming county government, and not only non-cooperative but non-compliant. And the evidence we're going to present to you should lead you to only one conclusion: deny this petition, or at the very least table it indefinitely until 2 things occur. 1, they dismiss the counterclaim they've brought against county government, and 2, you receive not only written commitments that are allowed, as you all know, for Indiana Code 36-7-4-1015 as to timetables for the so-called 6 phases of construction, but I would suggest liquidated damages as well if they don't produce. Now, I'd like to introduce, again, a couple of documents into the record. We have passed out for you the Plan Commission minutes, and I wanted to walk through some of those just briefly. Key sections that I wanted to point out to you from that meeting back on August 25th, 2015. You see the quotes there. We've taken excerpts. Mr. Volz stood before you 8 years ago and said his client will provide information. This is page 2 of your packet. The Plan Commission will show, and not to use a legal term, but beyond a reasonable doubt, his intentions are concerning...
Excuse me, Mr. Friedman, since he's representing the commissioners, do we allow a bit more time, or where do we go from
Let's
here?
show Freeman, we got to put a limit on the time somehow.
And I will try to keep it moving, but again, I appreciate the help with us representing an entity, the Board of Commissioners. And I will try to be efficient with my time. Thank you, Madam Chair.
Thank you.
Again, page 2, beyond a reasonable doubt, a shadow of a doubt, said Mr. Volz, his intentions concerning a property zoned R1, his intentions to construct a home on this property, and Mr. Volz then turned it over to Mr. Miller. You see at page 3 the representations about the sand. His 5-year process, he plans to pull multiple permits. He wants to plan and submit a septic permit, design specifications for a as we sit here 8 years later, never a septic permit application, never a building permit application submitted to the board, to the building commissioner. Page 4. He hopes to complete it within 5 years. Pond might be half constructed, a second pond, the 2 tied together. Mr. Pressel asked a reasonable question. How deep do you anticipate the pond going? Mr. Miller said that's a trick question. It's not a trick question. How deep do you anticipate it going? Mr. Pressel then pressed at page 4 as well, which was interesting as well. The board members did their level best to try to get good information from this applicant.
Excuse me, Mr. Friedman, I appreciate what you're doing and the fact that you're going through all this, but you
I'm
did...
not going to go page by page, I
Okay,
promise.
so you did pass it out where you've got highlighted, so
Yes.
if you could maybe...
Absolutely.
Thank you.
And I want to point you as well to page 50. That would be my
All right.
last reference.
Thank you.
Okay. Attorney Volt said the issue remains Mr. Miller's in a unique position to allow him to fulfill one of his dreams of owning a home and a pond, and he can build a pond. That's my last reference to the...
What page was that last one?
Page 15. Page 15.
Thank you.
Now, again, there have been 4 stop work orders. One that was enacted in 2015, another one in 2019, and we were back in front of the Board of Zoning Appeals in 2019 on an appeal from a stop work order. At that point, Annie Poland, your former building commissioner, had imposed a stop work order. And so, yeah, if we could provide those. I've got references from the cross-examination of Annie Poland, Mr. Volz, that I'd like to make sure that you're presented with.
If I may, Madam President, was this testimony in the litigation?
Yes, you know what I quoted? Quoted the BZA testimony. You'll see the, I'll get you a copy.
All right, because I don't want to get too far into litigation. It's not the issue here
But
tonight.
it referenced the BZA testimony. Mr. Volz cross-examined Annie Poland. And that's why I think it is.
In the case, but that case, the case pending is MS4, correct?
No. She was cross-examined at this podium when she testified at the BZA. That's why I'm seeking it.
Okay, well, I want to be clear, it wasn't testimony, they were comments. She was not under oath. I don't even know what it is, but I'm just saying. I want to make sure the
So you get copies
board
of it.
is aware and stays clear that this petition has nothing to do with the pending litigation. Okay.
Again, with due respect, they made it part of this litigation when they stood up in front of Judge Clymer and said they wanted this plan commission approval so that they could then seek to dissolve the litigation.
I understand your arguments.
Okay, and that's.
And Mr. Friedman, once again, I appreciate your input, but I think we're going to do the 3-minute limit and then we'll move on
Okay,
to the
can
next
I-
remonstrator, please.
All right.
Ashley.
Can I just finish giving you the documents that I need to give you? The Board of Commissioners has been involved in litigation for 8 years on this. Four
Okay,
stop
well-
work orders. I need just a couple more minutes to finish giving you the documentation.
I'm going to let the board make that decision. Excuse me, that is not allowed, but thank you for your,
To let Mr. Friedman present the evidence.
all right, we'll go ahead. Is that okay with everybody on the board to allow him to finish presentation?
How many minutes will it take?
Can you give us,
5 to 7?
okay, you got 6.
All right.
Thank you.
Fair enough. We have presented you, and again, an evidence of the non-compliance. Ms. Pullen makes a reasonable request in 2018. When are you going to complete the pond? When are you going to complete the pond? Mr. Volz then responds to your building commissioner and says, with all due respect, I'm not going to tell you. Frankly, folks, that's not what you expect out of your petitioners. You expect a level of participation and consistency. I've also got for you copies of the Rule 5 notice. Again, the reasons given for this have varied over time. I'm also going to provide you copies.
Want your paper clips back, are you okay with it? Hand them out, sir. Thank you.
Mr. Bijie, I'm going to object to this point as to relevance to the petition that's on the table before this board. Dragging up cases and issues and testimony and throwing me under the bus, quite frankly, for comments that I made back in 2015, 2016, 2017. We are here on a petition that was filed in 2023. None of this has any relevance whatsoever.
You know what? We're all held to the representations we make on behalf of our clients. This isn't another client. This is D&M appearing before this board. Now, what I gave you was a copy of the inquiry before the that was made of Ms. Poland. You've also got excerpts of the questioning that took place here, where Mr. Volz, in fact, inquired of Annie Poland, because he said, is there any prerequisite for someone who states they're going to build a home, they follow through? I think when you have something this controversial, you stick to your word. Those are the words of Annie Poland. That was what someone does with their own property controversial. He brought it up. He's the one who said he was going to have his dream home there. That's not anything anybody else said. The pond basin is complete. Wouldn't it be reasonable to conclude a dream home could be following? You would have thought by now. Now, in terms of the pond basin itself, I want to provide you copies. Let's show the copy of the court finding. Because I think it is important for this board to see what has now gone in front of a judge and evidence of non-compliance and non-cooperation. What I'm giving you is a 2-page excerpt, and you're getting the full copy of the special findings of Judge Clymer that were issued August 4th. But you see on this board, findings of fact on where there's been non-compliance by this particular petition. And I suggest you, with all due respect, it is important that this board consider that as well. I would also ask, with all due respect, that you take a look at probably the most compelling exhibit of all, and it's fairly recent. They were in front of a plat committee meeting just 2 months ago in August, they were in front of a plat committee meeting, and you all should have those plat committee meeting minutes. We should have plat committee meeting minutes that was designed to review the subdivision. And again, I want to give special credit to Mr. Vicari, the new MS4 coordinator, who did an exceptional job with his review, some of the critique. He's already turned down their initial petition for an MS4 permit for the subdivision. But in the course of that, I need you to look at the fact that within the course of a half an hour, the story changed. Initially, Mr. Miller and his consultants said, yep, it's a dry pond, it's not holding any water. We still got to apply some clay to the southeast portion. Well, you know what, that's what they told Annie Poland 5 years ago in that letter that was given to you. And then they changed later on as they get pressure from some of the folks in the plat committee. Later on in the meeting, you'll see just, I think it's at page 15, there's a reference to, well, no, it's not a dry retention pond anymore, it's going to be a pond. It's going to hold water. Which is it? Folks, I would submit to you, none of this holds water. None of this holds water. And you look at the contradictions made in front of your very plat committee, which met in August of 2023. And they were asking good questions. Mr. Poland's asking questions, Mr. Vicari's asking questions, and they can't even stick to a story. It's either a dry retention pond or it is a pond that's holding water. And you look at the very plat committee minutes, and that in itself gives you a basis to deny this petition. So again, thank you, Madam Chair, for allowing me some additional time, but we thought it was important. The Board of Commissioners felt it important to get all this information in front of the board.
Okay. Thank you.
Thank you.
Mr. Friedman, just briefly, if you indulge me. As the Board of Commissioners is currently an adverse party to DNM, would it, and I know the litigation word has been thrown out, would it be appropriate for me to recuse myself simply because if there is a challenge, I would, however the board's going to go. You understand where I'm going with
Sure.
it?
But I think legal questions should be addressed to me.
Sure,
Not demonstrate.
He's here at the direction of the president, representing the commissioners, and hopefully both of you can agree with wherever that should go.
I don't think you're disqualified. You're going to be making the decision later anyway.
And I think there has always been a member of the county commission serving on the plan commission. So no, again, you've got no financial interest. You've got nothing that would force your recusal.
Thank you.
You bet. Thank you.
Okay, thank you. Okay. All right, before we move on to more public comment remonstrators, just keep in mind that we are here for the decision for the petition in front of us, and that we're not going to be rehashing any comments. We'd like new comments. So any comments are welcome, but please keep in mind for each and every one of you that do come up, please state your name and your address, and try to keep in new comments, please. All right, thank you. Yes.
My name is Pat Meany. I reside at 4078 West Schultz Road. Madam President. Madam President. Thank you. Okay. See, Mr. Volz, I have the same. Always talking.
Could you please restate your name?
Sure, I will. My name is Meany, Pat Meany. I reside at 4078 West Schultz Road. And, geez, I hope I don't take as long as Mr. Friedman.
Well, you will have 3 minutes.
But maybe you guys will grant me a moment or two. I'm not going to argue about what was presented 8 years ago, although I could understand why Mr. Friedman might. I'm here basically tonight with a little 2-page statement, and I think it actually sticks to violations that I agree happened in Article 4, which is what the primary plat is all about, okay? So I think I'm going to stay on subject with that. So I have some belief in this, that the petition, I believe, and we'll get into why, I believe it should be denied, or at the very least it should be tabled. It should be sent back for administrative review until the following application comes into compliance with this ordinance. I believe there is violations of this ordinance that occur in the following sections. Section 04.02B and section 04-3 parentheses B.
Wait, one more time, please.
Sure, I got the last one mixed up. 04.02B and section 04-3B, okay? Now, I'm probably going to say this wrong, and I'm probably going to get yelled at, but when I read the two administrative review processes that were involved in this plat committee, one of these was an application for administrative review that went to the, like, Poland, and it was supposed to be kind of like a little primary review where the subdivider would give the information to Poland, Poland would review it and tell the subdivider how to tighten up. And then what we have is the second administrative technical review, okay? And under that technical review, there's a bunch of department heads that need to be incorporated into it. Some are going to say it's up to the enforcement officer as to whether or not he wants to include it. But I believe that because of this petitioner, we should take extra time to make all of the things in this petition factual. So what I'm going to say is, according to this section, the surveyor was required to sit in on this review. The surveyor, having designed this subdivision, I believe that at the very least, the county should have hired a certified, licensed, professional engineer to review the work of the county surveyor who developed this idea with Mr. Matt here. I think if we had done that, we would give this commission all of the peace of mind that they're going to need to sit back and say, we covered our base.
Mr. Meany, I hate to interrupt you, but how much longer do you think you're going to need?
Well, I think I'm going to need my whole 3 minutes, and I've got a page and a half.
Well, you already had your 3 minutes.
Well, you know, Madam President, down in Marion County, they allow 20 minutes for everybody who does this. So I would like a few more extra minutes.
Okay, you can have.
Now, I'm not, you know, these guys can stand up here and they can give a 15, 16, 20-minute presentation, and you're going to tell me I got 3 minutes. I only got another page.
I understand. That's okay. Continue.
Thank you. I'd like to know if the health department has signed off on this. I'd like to know if MS4 department has signed off on this. Section 04.3H and 4, under the conditions for approval of the petition at this meeting, they must meet the following. So what you must meet under the administrative review, and Mr. Volz is absolutely right, condition. Number 4 reads, provision for drainage design. Has that been done? Has it been submitted? Do we have an okay from MS4 for that? Going forward, the petition runs county to, in my opinion, the LaPorte County Land Development Plan in the following way. Our area out there, although it is planned urban area, the general objects are discouraged. The general objective is to discourage residential development that does not have immediate or near-term conditions for sewer or water. The zoning density that they recommend for that is 2 to 3 acres in many locations. And this is what Mr. Miller has designed his home to be, or the subdivisions to be. He's designed it to be that heavy density. In the planning subdivision, in the planning for this subdivision, the county has a responsibility not only to look at his request, but all requests granted by the Plan Commission. Mr. Miller wants 39 lots with the HOA not developed. A lot across the street, we've got a minor subdivision that hasn't been built yet that this commission approved for 3 lots and 1 more on a parent lot. And we've got 5 more lots down the road. So our neighborhood is looking at a total of 49 lots getting ready to be developed. No sewer, no water, no nothing. So what I believe this is way too many. And the thing I'd like to address now is the plat committee meetings of both August and October. I read both of those plat committee meetings. In my opinion, this was a dog and pony show to allow Mr. Miller to present his entire petition at one time to the plat committee, complete with his lawyer, his developer, and to some department heads, although all of them were not there, and the enforcement officer. And in those two meetings, they gave him guidance on how to fill his crap out. And Mr. Miller told them what he agrees and doesn't agree with. But not one neighbor, after 8 years of BS, was allowed or invited to that meeting. Why is that? So, there were a few people that did a really great job in that meeting. And I would say that there was a comment made by Paul Kari where he said, "Oh, did I say something wrong?" I think you got a nice MS4 coordinator there, a lot better than the last one. So this is what I would like to see, okay? I'm not opposed to Mr. Miller's subdivision. Gladly take it any day of the week over the last 8 years of what we faced. I'd like to see the lot numbers reduced. I think that with 50 lots being built in our neighborhood with no water and sewer and no intention to bring water and sewer to our neighborhood, the density is too much. And I disagree with the numbers that his developer stated for density numbers. I think what I would like to see is for the county government to appoint a representative that works hand in hand with Mr. Miller, sets up a timeline, sets up a time schedule, and makes sure that he performs to the guarantees that he has made with the 6 phases in the development of this subdevelopment. This is going to guarantee that the project keeps moving forward, a beginning, a middle, and an end, okay? The thing I don't want to see, and Mrs. President, I'm about yay far away from finishing up, the thing I don't want to see is the roads destroyed. I don't want to, speaking for myself, I'd like to see the 8 years of industrial sand removal quit. And that's about all I got to say. Thank you.
Thank you.
And it gave me dry mouth to say it.
Okay, any other remonstrators for or against the petition, please?
Good evening. Thank you for your time. My name is Jacqueline Thomas. I live at 3484 North 400 West. I appreciate the commission giving the remonstrators time to talk about this potential subdivision. 8 years ago, my husband and I, we bought our dream home here in LaPorte County. We moved from out of the county, found a nice spot on a couple of acres, and we lived there for about 6 months before all of this started. I will tell you, I have got a crash course in county politics, and it has been really interesting, and I've learned more about zoning and plumbing and drainage and all of that. But what really just doesn't sit right with me as a potential neighbor to this development is that it is my opinion that, if you look back on August 29th at the Plan Commission, as Shaw Freeman was talking about, on page 2 of the handout from the August 29th meeting, it talks about if the pond is going to hold water versus if it doesn't hold water. Literally 20 minutes in the same meeting, it contradicts itself. On page 15, you'll find the contradiction where it holds water or it doesn't hold water. So I asked the county commission, I'm a parent, and if my kid came to me and said, "Mom, I'm going out with friends and I'm going to be here and this is where I'm going to be," and then my kid came back to me and said, "Oh no, I'm going out with these friends." As a parent, I would go, you know what, something doesn't hold up here, something's not working, I'm not getting the full story, I'm not getting the truth. And through what Shaw had to show the commission, through what neighbors, my neighbors have stacks and stacks of paperwork, unbelievable amounts of paperwork for this thing, where time and time again, D&M Excavating has stood up there and said, we're going to do this, we commit to doing, building a pond and a dream home. There's no pond, there's no dream home. What our neighborhood has been left with is destroyed roads that had to be repaved, I believe, I'm not 100% certain, but I believe at the taxpayer's expense. I don't want to pay for that. Nobody pays, no. We've had accidents with dump trucks out there. I mean, it's a circus. And so I urge the commission to please look at what has happened within, right? As the president said, we're going to talk about not hypotheticals. We're going to talk tonight about facts, about what has happened. In the 8 years, this gentleman has not been a good neighbor at all. And I urge the I urge this commission to look at the track record, look at the documents. It's a mess. Please do not approve this. Thank you.
Thank you. Okay. Could you give us your name and address?
Randall Beach, 4177 West Schultz Road.
Thank you.
I did.
There's two per deal, okay.
Thank you. We can share.
You can get you, yeah. I'm scared she can get it.
All right, I'm going to take out a bunch of the niceties I had in here because of the time restraints we've been put on. Many promises have been made and many promises broken. We're hearing them here tonight. We, the neighborhood, have lived them. I have always been very vocal on the noise, the pollution, the dust, and the debris. All this is very common at construction excavation sites. When the site was first brought to the attention of the neighborhood, we felt the project was being rushed in. When we addressed missing permits and authorizations, we didn't get any answers. When we were further amazed to find many things were accomplished over a holiday weekend. That was covering 4th of July 2015. We feared then to what is being played out today, directly behind my house. An industrial sand excavation site that has sold thousands of truckloads of sand. But let's not get ahead of ourselves. One of the first items I started to question was when the road and the size of it going back to the sand area. It was 15-foot high roadway that blocked the natural stormwater runoff during a heavy rain. On the handout I gave you, there's pages that include the rain amount in 2008 and the rain amount in July of 2015, and also a plat layout that shows the actual stormwater runoff, which is the main line going in, a red arrow pointing to where my house is. The pond, the green dot back there is the supposed pond. That isn't a pond, that is a retention area that isn't, we don't know what it is right now. Through all the reports, I found 4 different items mentioned on it. It shows that there's a main vein of water during stormwater runoff that goes to this area. While I'm addressing the drainage that goes through my property with the sand pit owner, I was told that a 10-inch drain culvert was a sufficient size to handle the rainfall that would be expected in the area. And after I had the discussion, it was decided to appease me that they had put in another 20-inch cistern culvert pipe right next to the one installed. On July 18th, on the paper that I gave to you, you can see that we got 1.53 inches of rain. It was a downpour. It was a downpour. Because of the poor calculations on the driveway and the extreme undersized drainage pipe, I ended up with 6 foot of water flooding my property. D&M then put in an additional 32-inch drain. That's a sizable mistake. Put in an additional 32-inch drain pipe next to the 2 that were already in place. That cured the blockage flowing onto his property, but did not fix the damage on mine. When that rain did back up, it changed the flow, natural flow. The natural flow had been altered. It had been there for hundreds of years. It was no more than, I've had the property since November '99. Back in 2008, I had a 6.73 inch rainfall. I didn't have any flooding. Now I get 1.5 inches of rain and my property floods. And the only thing that's changed is is what is obviously a 15-foot roadway and the restricted flow design. Now my water must run to one central point, where prior to this being put in, it had a natural flow everywhere. For those of you coming into this, I'm getting ahead of myself. I believe the county is in the middle of a couple of subdivision stormwater runoff issues right now. For those who are coming into it well after the fact, so far in this one, you only have one affected resident. That is me. By putting in the subdivision, you're going to have the additional water flows going into that pond. I've heard some calculations and some numbers that don't show it's going to add up too well. I hope you all do your due diligence on the 151 acres that show up on this property that it drains into this pond, because it all does flow next to my house. Next we're moving to the July 26, 2016 Plan Commission meeting. We're meeting to see if the pond permit was for 1 year or two. The longevity doesn't matter because it didn't happen anyway. Then there's where the neighbor found out about our property rights we possessed were turned into word salads by legal representatives. As the legal counsel...
Excuse me, Mr. Veach, are you wrapping it up?
Yes, I am.
All right.
The legal counsel thought he should name us something derogatory. Next, we all became sand people, no longer normal citizens. Not the property owners that had bought their residential properties, wanting to live in harmony of an industrial-free neighborhood, an environment that we paid for and were taxed for. We were called out for complaining about things we didn't want. The sights and smell that come with an industrial excavation site, waking up at 5 a.m. on some days to the bangs of trucks. The constant cleaning of sand made if you made a mistake of leaving the window open to your home. The cleaning of the dustpan full of sand if you had to brush off your outside porch. Tailgate slamming, the smell of diesel fumes, the noises of bulldozers, excavators operating at the industrial level needed to supply all CHC sand needed for multiple commercial grade construction sites located throughout LaPorte County. Not all trucks came back empty. Materials were hauled in and put where? What was the material? It should all be documented. They were following MS4 guidelines according to the property owner.
Excuse me, Mr. Veach.
Yes.
We're discussing the agenda for this evening for the petition.
Yes, I understand, and I'm getting to that right now.
Well, we need to...
Well, you're over on time. You're over on time, sir. Point of order.
Madam President,
Excuse me, Mr. Veach.
Yes.
We're not going to allow that, but
Okay, thank you.
Mr. Cunningham would like to speak.
Madam President, I haven't heard him repeat himself. I'd make a motion to extend.
Okay, thank you. A second?
All right, the materials that were...
Excuse me. Is there a second?
Second.
Okay. All those in favor signify by saying aye.
Aye.
Opposed?
Thank
Okay,
you very
thank you.
much.
All right. Thank you.
Maybe if I slow down, I won't stutter so much and have to do some repeating. All right, materials that were hauled in and put where? What was the material? It should all be documented following the MS4 guidelines. For full disclosure, if this property is subdivided, will it show up on any of the deeds of what materials got hauled in there, where it was dumped? If not, why won't it show up? The property was used as a borrow pit for over 4 years after the pond was said to be completed. Then they changed it to contouring and tree removal for a couple more years of soil movement in and out of the property. Let's jump to present day. This property is presently in court under litigation for doing just what I talked about. The property owner has not been able to remove or sell CHC sand for months now. The fact that the judge has moved the next court date out to the summer of 2024, is this why we need a new name for the digs? I was going through the plan technical review for Sable Estates. It was a very pleasant review. Everything was not rubber stamped like it was for the last 8 years. I'd like to commend Paul Bakari for following true MS4 guidelines. He has found many errors on the submitted paperwork. Most of these were always present on past paperwork and were turned in marked as adequate. I noticed many more that have not been pointed out. paperwork of this nature being turned in for a major subdivision should not have any contestable errors. As a professional courtesy, I'm not going to point out the ones that I have seen, and they are glaring. I was also reading through a couple of the months of Plat Committee meeting minutes. One glaring omission is that there isn't anyone from the neighborhood that can offer any input. We're the ones that have endured multiple years of an intrusive business that disrupted our daily lives. You would think after 8 years, the hole in the ground would be able to be called something, not 4 things. The report says pond, stormwater runoff area, retention pond, dry bottom retention pond. All 4 have different meanings and different rules that apply. The comments are made that we're going to have to have this through the plan no matter what, and there'll still be deficiencies. Then why present it? There are marching orders to move forward. There are certain deadlines that are out there and other factors. As in what? They are late in the construction season at this point. That is why they need to be on the agenda for the October meeting. Late for what? Why the sudden rush for a borrow pit? I mean, oops, fine. Wait, no, wait. We're going to call it a subdivision now. I can see many more details of land contouring happening on this project. Many elevations are showing up. One detail not seen in the current plans are what the current elevation is. I can see where he's going to dig down 5, 10, 15 feet from what? 20 feet up? How long are we going to dig? I took a drive by the D&M plant this morning. Plant 1, that he liked to be called, because the area behind my house was called Plant 2. I was looking for the sand mound that they had stockpiled up before closing the excavation site earlier this year. You used to be able to see it from Patriot Park, 300 North, and from the Speedway parking lot. Now it cannot be seen. Is that the hurry and the need now for this subdivision and the right to dig more sand? Or is there another contract that needs to be fulfilled? Because we all know that's what happened last time. How many years does each phase get? Right now, are we going to go back to digging for every day for another 3, 4, 6 years? There's no time frames listed on any paperwork. Is the county working together in unity to let all the legal matters get settled in this case? After 8 years and over $250,000 being spent to shut down the industrial excavating business, now we hurry and give them new digging options that may or may not pan out for the county plan? If this cannot be tabled at this time, until a time that all legal avenues are cleared up, at least table it until some benchmark places are put in, so we just don't revert back to what we had, a never-ended project that's just a bunch of lies. Thank you very much for your time.
Thank you. Any other remonstrators for or against the petition? Any other remonstrators for or against the petition? Okay, seeing or hearing none? Okay. Mr. Volz, would you like to address?
Again, or
Yes, please.
my name is Matthew Garitano from Charles Hendricks and Associates at Surveying and Engineering. Going to try and touch on the items that I can that are pertinent to Charles Hendricks and Associates and the petition. The most recent, although it came from the last remonstrator, there is a time gate for this process. So for the first phase, once approved, the construction plans are approved, 2 years for the applicant to build phase 1. That's it. If it's not done in those first 2 years, he has to start this process all over again. The MS4 permit for the site is good for 5 years once approved. So there are time gates pertinent to this petition application. It's not never ending.
Madam
Mr.
President,
Cunningham.
question.
Yeah.
Does the building commissioner have the authority to extend that from 2 years to 3 years?
I
Discretion?
I can't personally speak on that.
Vaughn, do you have that authority?
I believe I do, yes.
We've passed them in the past where The commission's put a deadline by which they must construct, and I think gave the building commissioner authority to extend for another period of time if requested. So you can make those as requirements in your decision.
I'll just make sure I get this straight. Phase one could go 3 years,
No, 2 years is the rule, I believe.
plus a year of,
Yeah, I can't state it.
well, you just said that they've done that in the past, so I think that precedent's been set. Okay, so then you have a year to ask for permission to move into phase two, correct?
I'm sorry? They
Have a
another
year to then request to start phase two, correct?
Right.
So that could be 4 years out. And then do you have 2 or 3 years to do phase two?
It's my understanding that the construction plans are done all at once, so all 6 phases. The construction plans for the subdivision, regardless if he's just doing 1 phase or all 6 phases, that has to be approved. And then as far as the time gate, whether it be 1 plus an additional 1, that between the building commissioner and the applicant, I can't state as to what that's going to be. Is that going to be for all phases? I don't know. I can't tell you.
And the reason I asked that question is doing the math, based on what I read in the plat commission, it could look like 20 years, potentially.
Not necessarily, considering the whole subdivision is still under the guise of the MS4 plan once it's approved for the whole site, which is bound by 5 years. Well, it's not 20, it's 5. If he doesn't finish in 5, then another MS4 plan has to be approved.
Let me maybe shorten the discussion. The commission can set whatever deadlines it wants, okay? Or the commission can instruct the petitioner to provide a timeline with the construction plans, because they got to come back again before they can start building with the final plans. So you have a lot of discretion there on how quickly you want anything finished, built, or completed.
Thank you.
Okay. Thank you. Continue, Matt.
The next thing, MS4 plan application. The MS4 plan application has been reviewed once and sent back to MS4. It is under second review. That process is ongoing. I believe MS4 has a time limit as to when they're going to get those back to us. So that is the process. That's how it's set up. We submit the plan, they review it just like the technical advisory board. The next thing, most importantly, that I want to speak on was the multiple comments on the pond will be dry, the pond will be wet. The pond will be dry. That was my personal mistake. I made that in the technical advisory, the first meeting. And the specificity to that comment, why Mr. Bakari was worried about it, was he was worried about the level of water in the pond. The water being too low, he didn't want the water too low for invasive wetland weeds to choke the pond out to limit its capacity. So it wasn't a matter of too much water, it was a matter of not enough water. The pond level that people may be concerned about will be specified in the construction plans when they're presented to the county engineer for approval, a licensed professional engineer. That is the next step. We have to get through this phase, this primary plat approval, to get to that phase to present the construction plans. The next comment that I can speak on was density. It sounded like remonstrators wanted to reduce the number of sites. R1B, as you can see on the first sheet, is rated at 1.8 dwellings per acre. We're at 1.02. We've already reduced it per the requirement in R1B. So we've taken that into consideration with this application. The next comment that I can speak on was water and sewer. You can see on sheet 10, we brought that up, 8,947 feet plus or minus to the nearest sewer line, with an approximate cost of $1.83 million. But it doesn't matter because the city of LaPorte will not annex or will not allow you to tap into sewer and water without annexation. So it doesn't matter. There's nothing that we can do there as far as planning. Other than that, the technical advisory meeting, that discussion I shouldn't say deficiencies, but questions and concerns in the technical advisory meeting is why we have those meetings. They shouldn't be cause for stopping or denying a permit application, I wouldn't think. That's why we have them. That's why we have them with all the different technical people from each department, is to go over their comments and concerns. I feel like we did that. All the other items, unfortunately, I don't feel I can comment on.
One other question, if possible, regarding the depth of the pond and some of the materials from the plat commission meetings. I see 30 feet deep, possibly the pond at one end is 30 feet deep.
Yeah, so
Really accurate?
it's amoeba shaped. It's not perfectly circular. So
Approximately 30 feet deep.
yeah, if you look at sheets, I wrote it down here.
Well, my
I
question
think
is,
at the breadth there, I'm looking at a contour at about 820 to about 796. It's about 24 feet, and that's at that long, sloping south side of the pond. But it's not like that all the way around.
do you have any idea how deep you have to go to get water there?
I don't have any coring samples for the soil as far as what, like I said, we didn't have access to the soil reports, and I don't believe he did.
Have you checked with any of
the pond?
any of the neighbors how deep they had to go to get their wells?
No, I don't.
Thank you.
Any other questions?
Anything
You
else from
okay
the
with
board?
us, Matt?
Yeah.
Don't give us that look again.
What look?
That look. I saw it before. Wells are an important thing in any subdivision.
Absolutely.
We should have known how deep the wells are in that area.
Well, I believe his comment was how deep in the pond, if I'm not mistaken. Was your comment not how deep in
Last
the pond?
comment was how deep are the neighbors' wells?
I don't know the depth of every adjacent neighbor's well, no.
Any other questions from the board for Matt? All right, thank you, Matt. Okay. Okay.
If I may, I want to clear two things up, the commission and the public. The plat committee meetings are an interactive process. We're trying to identify issues and address those issues. How many times did we meet with Ovs? Got to be 20?
Right.
So that's where we work through this. So it's not an adversary process. It's not testimony. Okay, first of all, it's interactive. We have as many meetings as we think are necessary to make sure everything's addressed before it comes before the commission. Okay. Second point, and this might have been confusion, but the county did hire a certified engineer, Rick Wright, to review this because Hendricks was not going to be there. We knew that. So
Jeff, right?
Jeff Wright. I'm sorry, Jeff. He wore a coat and everything tonight. But just so the public knows, we did hire someone and make sure they were there, and we had somebody to review it. Okay, those are the only comments I had, and I did run off the page that's relevant from the subdivision control ordinance that indicates the factors on which you decide this matter.
And we do need to point out that this is just primary plat, that they will need to come back.
Right, when they come back, they'll come back with the construction plans and be much more specific. And this has still got to go to county commissioners yet after this meeting.
Correct. Okay.
So we're just making a recommendation to approve.
Yes. So at this point, the board needs to decide if they have any other concerns or questions that they would like to address to the attorney and or Matt again, or our county counsel. Otherwise, I guess we're going to hear from Mr. Volz at this time. Is there any questions or anything else that we need to address prior to? Okay, all right, thank you.
I guess I have one question, because I mean, this thing has all been bounded around this borrow pit, this sand pit. How many loads in the construction of this, the phase of 1 and 2, how many loads are of filter are planned to leave this property?
We can't answer that question here at this point because we're still working through construction plans. And again, quite frankly, and I apologize for bringing this back up again, there are certain items that are in front of this commission that are to be determined on. And this, and this, it's irrelevant. It's completely irrelevant. This is a submission for a major subdivision, the likes of which has not been seen in LaPorte County in 10 years. This is to provide homes, specifically for, well, when you look at it, this new battery plant and whatever else, you've got skilled workers coming in here that are looking for places to live. And they don't exist in LaPorte County. They don't. They don't exist in New Carlisle. They don't exist in West St. Joe County. They don't exist. This is a high-end subdivision. And whether or not you believe anything that any of these other remonstrators have said, or the fact that the previous county attorney got up here and advocated on behalf of the commissioners, once again, it's irrelevant. You have 7 items that you have to consider in order to pass, in order to give a favorable ruling to this. That's it. It's a ministerial function. And I'm not saying that we're not going to come back after we get a favorable ruling with construction plans, et cetera, that are more detailed, even though they don't need to be more detailed, because this is the most detailed major subdivision petition that Matt has ever submitted in his 20 years of practice. We're not playing around here. We're doing the things that, quite frankly, even to drag the county back into it, we're doing exactly what the county wanted us to do. We've submitted a plan, and now we're being told we can't go through with the plan. It makes no sense. But that being said, all of that aside, we have a petition in front of you, and it's based upon only the petition with the certain elements under Article 4 that need to be met. We believe that they've been met, and we would ask that the petition be granted. Thank you.
Thank you. Okay. At this point, the subdivision review and approval procedures that they've been alluding to this evening, that our county attorney did give to all of us on the board to redirect us to the fact that the Plan Commission shall determine if the subdivision plat qualifies for primary approval under the standards prescribed by the ordinance. So we've heard it a couple times, that's been reiterated, and that's what our position is here for this evening. It's for us to give a favorable recommendation or a non-favorable recommendation for the petition that's before us. So as we've heard, that this is going to bring will bring jobs, will bring tax revenue. So there are some benefits to the subdivisions being brought into LaPorte County. And to reiterate for everybody's comments to help with the fact that, yes, this is the primary plat. We will see a secondary plat hearing that will come before us again before anything can move forward. So with that being said, are there any other comments from the board or questions either for our legal or for Mike this evening before any other discussion?
This is quite a contrary for us to have legal teams come in from something else other than what we're doing planning. So I understand both requirements, but as you said, all we can do is accept the subdivision as being okay at the time, and you say it meets all legal stuff right now, correct?
Well, it's met the plat committee requirements. So, that's your decision to make. Mr. Freeman spoke. Again, I don't think it's relevant, and that issue will probably be addressed again someday. But he has his record. But now you got to decide if you're going to let it go forward to the commissioners or not.
And Mr. Beachy, you would point out that they are able to
Yeah, I'll remind you. Yeah, they can. You can impose conditions.
And would that be this evening, or would that be on the secondary return?
Well, the type of conditions you would impose on the primary would be things that you want to see in the construction plans or restrictions that you want to design into the construction plans. Wells, for example, or required information for the next step. Okay? So, timelines.
Okay.
You can, or you instruct them to give you specific timelines, or on the construction plans, you want timelines within a certain period of time. Things like that.
So have we developed anything else we want from them? We've batted around a lot of things.
Well, the plat committee works they work with the petitioner to get it worked up to where all the requirements are met by the county, okay? At least on the initial plat. But that's where they stop, because any conditions should come from the plan commission.
That's why we're asking this to be tabled, until conditions can be placed.
Shaw, point of order, please. I'm trying to keep the
Say,
record.
Mr.
Get on the if you're going to be out of order, get on the microphone so we have a
You
record.
come to the microphone, state your name, please, and then
Shaw Friedman, attorney for the Board of Commissioners, and I made clear you have full authority within the statute to table this until the conditions are in.
I take issue with my giving my client advice and you interrupting Shaw. I am instructing my client. I'm now instructing my client. Okay? Yeah, go to the podium so somebody can hear that you're out of order, basically.
I represent the Board of County Commissioners.
And you've already remonstrated. I'm talking.
Mr. Bolts had an opportunity to respond, Doug, and I'm simply responding and asking and providing what our
That's not our process here. That's not our process. Comments are closed. They're asking questions illegal. Please sit down.
Fair enough.
Thank you.
yes. Thank you for your
This is
time.
not a
Yes,
commissioners
thank you for
meeting.
your-
Thank you.
Yes, and we have been advised by our legal counsel this evening for the board. And if you would like to reiterate that with us, please, for what we are allowed to do as far as the conditions and
You
things like
can,
that.
on the you can make any condition you want. There's really not a restriction on those conditions.
Can I make a motion to table?
Yeah.
Thank you. Motion
Second.
to table.
Can would you repeat the motion? Because I think you two over.
Motion to table.
Thank you.
I second.
Is there any discussion regarding the tabling of petition number 1 for DNM excavating?
What are we gonna require for them to be untabled? What's our time desired elements in here that we're gonna wanna go over if we're tabling it?
You can set a workshop in the meantime if you want.
I guess that's my question, is the reasoning for tabling is what are we going to do in the meantime before they come back next month or 2 months or whenever it is that they need to come back?
I mean, that's the whole problem here. I mean, the area is designated to have homes on it. It's less dense than the adjoining subdivisions, which are continuous to it to the west. I mean, I don't understand.
Actually, you're right.
And I guess my concern is we're tabling it, but we've been over the fact that we can do conditions. We are here this evening to only look at, to determine if the subdivision qualifies from the primary approval.
Yeah, and Mitch just reminded me, and thank you, Mitch. So there's another document that will come about at some point, and that'll be before they can come before you in the second phase, and that would be a subdivision construction agreement. And so any conditions that you would set forth at this stage, I know we're on discussion on voting on the table, but I want to make sure you guys are comfortable with the procedure. So any conditions would be design conditions more than anything, okay? Or conditions on what you want in a construction agreement. That's basically a contract between the developer and LaPorte County saying, we are going to do this, this, and this, and the county says, okay, we're going to require you to do this, this, and this, okay? And those are usually a little more specific, and that's why they come in between primary plat and secondary plat.
And if we were to address the conditions this evening, they could at least include those in before they came back for the second.
Right, but if you want to have another workshop to discuss what those conditions would be, you can certainly, table it tonight and then set it for a workshop on another night.
The only thing I see out of all this is the water. We got trouble in the state already with Lebanon starting to develop it and not have enough water. Now, you haven't told us what the well levels are, if there's adequate water for all these houses to have individual water. We've already got trouble north of town with the water problem. So only problem I see in the whole thing is this water. Since it's a sand mine, where's the water?
Okay, so I guess my question then, to cuff off a Harold then, with the water, we're at primary. Before they could even move further past the secondary, they've got to have that information for us to be able to approve that.
I don't think we've ever done it. I think you can put conditions on the table
But I mean,
and tell them I want to see this, this, and this before we take it off the table.
but I mean, they can't
There's a
build
motion on the
if they
floor
don't
right
have
now.
that.
Motion on the floor with a second.
Okay. Okay. Any further discussion on the motion? Okay. All those in favor to table petitioner DNM excavating Do we table it for a month, or do we table it till they're ready to proceed for the next?
You can table it for a period of time, you can table it indefinitely, or you can table it on conditions. You know, this is tabled until we see 1, 2, 3, 4, 5. That would have to be an amendment to the motion, but
Would you like to amend?
In order to bring it back up, what would have to happen?
just simply a motion by one of the members.
Okay.
And a second, of course.
To amend the motion?
No, to bring it back, the petition back, once it's tabled.
Once it's tabled, you just need a motion, a second, and a vote to bring it back.
Okay, so we have a motion on the table and a second to table the petition. And
Wait a minute, we got words of wisdom coming up here.
Can we proceed to vote?
Harold?
Call the question?
Same thing with Shaw. Comments,
no, but he means
petitions are closed. It's board discussion.
Asking for clarification.
Call for
They haven't
vote.
voted yet.
Vote,
I'm just
Okay.
asking for clarification.
They gotta vote.
Okay,
vote.
thank you. Please have a seat, Mr. Volz, and we'll go ahead. Could I have we'd like a roll call vote, please, on the table for the petition.
Rita Beatty,
Aye.
John Carr,
Table.
Joe Haney,
Aye.
Earl Cunningham,
Aye.
Glenn Minnick,
Nay.
Deb Vance,
Aye.
Harold Parker.
Nay.
The ayes have it. Tabled.
Okay. All right. Thank you for your time. And petition number 1 has been tabled. We'll move on to petition number 2. LaPorte US 20 BTS Retail LLC and Nicholas Perlilli, represented by AR Engineering, respectfully petition the Plan Commission to rezone R4 to B2, the property located at 1621 West Springville Road, LaPorte, Springfield Township parcels.
But they were not clear on the
Notice is adequate.
Thank you.
and we already got a problem with one subdivision up there with water, all that no chemical. Plus the Lebanon issue, what they want, a million gallons an hour or something, or
Take a moment and wait for everybody to get into the hallway, please.
from Lafayette.
But that his connection with that battery plant, that was
Erosion. That was an erosion. And so was that.
Now there's no-
So was that subdivision.
And we need, there was just some pushing back there, but that can't go on.
That's why I call it.
the cops just sitting there sleeping.
Do we have,
This was pit.
do we have police out
He
there?
owed it.
Yeah, he just walked out.
Huh?
He just walked out.
Okay.
The bailiff?
Uh-oh.
That's cool. Really?
Yeah.
Get the cop out there.
Shut the door.
We're going to pause for a moment, please. And could someone please shut the door?
Oh, we don't have anybody in here now.
I know.
Oh, yeah, we don't do that.
Same thing out there. Don't forget your scaffolding.
Anybody want to borrow while it's up here?
I do have kindling I need tonight. I just came from Potato Creek. I need kindling. Yeah. That is not where we should conduct the building meeting, is out in the hallway.
We got one more petition, right?
We do.
Okay. Do we get put on overtime or something?
We got security out there. Yes. Point taken.
You mentioned it so well, you can say the wrong.
Yeah, what about to see if one move on to the bottom line?
Or like, see if like Curry one move on.
That's the primary meeting.
It is.
All right, thank you.
Keep all your
We
information.
can go ahead and continue.
I was going to say, was it something I
Wow.
Yes. No. But thank you.
It was
So-
something we said.
Exactly. So we are here for petition number 2. So
Correct.
please proceed.
My name's Tom Cowan. I'm with Zaremba Group out of Cleveland, Ohio. And I represent the petitioner. We have a we have a tag name for this property. It's LaPorte US 20 BTS Retail LLC. And all of our projects get that same tag on them. And that's the difference between the company name of Zaremba and LaPorte US 20, the petitioner. Good to be here tonight. I greatly appreciate how Port County handles these meetings. And we've been here many times before, Plan Commission and county commissioners, and it's just really well handled, on point, and I appreciate that. That is good.
Thank you.
Well, it's an exciting night.
Yes.
But what we're here for, very briefly, is that we're here for a rezoning of 0.483 acres of property that abuts a portion of another property that was rezoned 2 years ago. And that property was 1.563 acres. That was done in late 2020 and made official in January of 2021. Our intent back in 2021 was to build a Dollar General on the property. That is still our intent. The original acreage was needed for a 10,640 square foot retail store. That deal ended up transpiring mostly because the Indiana Department of Transportation has a major project on US 20. Everyone is aware of that. And it was a couple years down the road. So our client, Dollar General, wanted to pause the development, which they did. The good news is they now want to come back to the site, but they want to build a bigger store, which is better for the market. Our plan now is to build a 12,480 square foot DG market store. The market tag that goes with that means we're going to be adding a lot more fresh food, which a lot of people have said, we live in a food desert, can you get Dollar General to give us fresh food? They've heard that message. That's what they want to put here now. So it's a good thing things were paused for a couple of years. Now that we can come back to this, assuming that we can get the rezoning approved tonight, we can build a bigger and better store. With me tonight is Whitney Pizzala. She's our chief engineer with AR Engineering, and she has all the technical information, can answer questions about the site development itself, what we intend to do, how deep the wells are. I'm going to let Whitney speak for a couple of minutes on what we intend, just so we can share the current information, and you know, we're just delighted to have the larger store format that we can bring to town here.
Thank you.
Thanks, Tom. My name is Whitney Pizzala. I'm with AR Engineering. We're at 5725 Venture Park Drive in Kalamazoo. We're the civil engineer on the project, as Tom mentioned. We've been on this since from the beginning when we were back in 2020. Does that sound better?
Good.
Okay. And so, when, I don't know if you have the site plan in front of you. I did bring some extra copies if you want this.
We do. Thank you.
And so it's kind of similar to the last time. It's just the bigger store, the 12,000 store, which adds a little more parking, and which also with that, you know, we're asking for that rezone of that sliver of land because of the bigger store.
What was the previous store size?
Was this the 9? It was the 10,640.
And you want now? What now?
12,480.
You know what, I'm going to take that back. It was 9,200.
Was it?
Series?
It was 9,200.
Pick up.
It's changed.
And I just remember that because what happened was we were so far along that we had ordered a building and had it, we had the building put on the site, and then they changed the format to the 10640. This building was already bought and paid for, and the deal went on pause. So we came back to the site, picked up that building, and took it to an Ohio location, the very last location that we built at that smaller store size. So we did not lose money on buying that building. It was a happy ending for the Ohio site. Now we're gonna have one here. Sorry, I told you the 10640, I was wrong.
Thank you. It's okay.
So getting back to our site plan, so we have, so when we did this last time, we were almost essentially through all of our permits, before we were put on hold. So we had things like from the well, from the state. We still plan to connect to the sewer district, so that's still the plan, to have public sewer for this store. We've had numerous conversations with NDOT on access, so now with their road project, we'll be able to have full access here because they're widening for a center left turn lane through US 20, and we'll have a right turn decel lane into the site. So they were really interested in this project just because of US 20 and how much it serves. So it's a pretty typical layout. They will have delivery trucks. You'll usually see them on the highway, the big Dollar General trucks. Those are typically about once a week during store hours. And then they have intermediate box, smaller trucks for like the fresh foods, breads or sodas, stuff like that, throughout the week. That just come during opening hours. I can, if there's anything specific with the site plan, I can try to address now. This is kind of like our first step, and then once we get through commissioner's approval, we'll go into full design. So.
You plan on doing a good job, correct?
Yes.
Okay.
Whitney's in charge of the good job part.
Right, any other questions or concerns from the board at this time?
I assume you guys are going to send this out for bid to local contractors?
That is what we do. We have usually a general contractor that gets all the subs as local as it can be done. So there'll be a bidding process that'll come up.
Okay. Thank you. Okay, nothing from the board, so, and I do not see any remonstrators for or against the project. So, Mitch, did you want to say something? Oh, I'm sorry. Yes, if there was anybody online on the Zoom that wanted to comment. Right, thank you, Mitch.
What do we have to propose?
So-
A change in zoning first?
Yeah, that's the only thing we have to address, is a change from zoning from R4 to B2.
I make motion we do it.
Second.
Any discussion on the motion on the table to rezone from R4 to B2 on the property located at 1621 West Springville Road? Okay, all those in favor signify by saying aye.
Aye.
Any opposed? Motion carries. Congratulations and good luck.
Thanks for your patience.
Yes, thank you.
Should put them first.
Okay. Old
You should have been
business.
first.
Under old business.
Sorry to hold you up, yeah.
Should have brought a lawyer.
Under old business, since we had our last planning commission meeting, there's been another meeting with regard to fire inspections, safety, possible business licensing. So I've been asked to do some drafting, which, by the way, this is very uninteresting reading. But so I got some suggestions for the changes of zoning go. Dave Amber sent me some helpful email. But I want to, if the commission's okay with it, I want to wait to bring that back until I'm done drafting the other ordinances, because some of them may have some influence on the zoning code, depending on how we want to try to accomplish some of these goals. Okay?
That's a good idea. Do it all at once.
Yeah.
Yeah, and it's just gonna be a little while, because Randy Novak gave me the fire code, it was like that thick, so I get quite a bit.
Thanks, Randy.
No, I just keep me advised, making sure nobody has any objections. Okay?
He should have gave you the condensed version.
190.
Free, folks.
All right. Any other old business? How about new business?
Motion adjourned.
All those in favor signify by saying aye.
Aye.
Any opposed? Motion adjourned. Thank you all.
Everyone, you want all this?